back to Time Serve, the channel that scans the docket so you don't have to. I'm Phil, and today we visit Judge Colin Hunter's courtroom, and we see this guy who tests his patience at every turn. Judge Stephen gives his daily "I'm sick of you" speech. There's a swan song in Judge Simpson. And poor Judges Webster and Cooney have to deal with bellowing babies like this. And of course, some of the best and newest clips you unlikely haven't seen anywhere. Let me know in the comments who you would like to see most on the Daily Docket. Don't forget to hit that like and subscribe, set your notification to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds.
Appears that the order appointing the conflict counsel in the other cases has not been signed. That the judge don't file a conflict, but there's no order acting on the conflict. In the misdemeanor case, that order was signed, and then that regional conflict counsel had a conflict. So now Mr. Crainert's involved. So we're misdemeanor's 2 steps ahead of the felony. Mr. Gary, you have felony court set on the 23rd. That is 14 days from now. Yes, so sir. What I'm going to do is ask Mr. McDaniel's office to look into the status of the appointment. And Mr. McDaniel, if Judge Garcia hasn't been sent an order, she needs to be sent one, please, for her review. Actually, it may not be Judge Garcia.
That will be Judge Garcia. That may be the
delay may be caused by that.
When they e-filed it, it went to Judge Garcia. She probably deleted it and said, no, I can't sign it. And then the other judge don't know about it, I suspect.
It's a judge from Okaloosa.
I don't even know what circuit Judge Brown is in. But you've got court before Judge Brown on August what day did I say? 23rd. On August the 23rd. In 14 days. In 2 weeks, you have court before Judge Brown. So what we're going to do is we're going to set this case for the same day, for August 23rd. Now, the felony case is in the afternoon. I'm going to set this case for the morning because we don't have court that afternoon. So I'm going to see you on the morning of the 23rd. I'm going to ask the clerk to renotice Mr. Cranert for that date. And then if he wants to call and appear by Zoom, that's fine. But we need to get him involved in this case because if Regional Conflict Counsel had a conflict in the misdemeanor, presumably they're going to have a conflict in the felony. And we need to get his case moving. Back to first appearance time, 8:30. I'm also going to ask the clerk to notify, notifying Judge Garcia's office because she's not involved in the case. I'm going to ask y'all to notify the felony clerk. So the felony clerk can notify Judge Brown of the issue. Okay, so if Jeannie would notify Judge Brown's office that there appears to be a delay, he's got court coming up and doesn't even have an attorney at this point. So, Mr. Gary, I'm doing everything I can to get your case moving. You're going to be in front of a judge August 23rd, and I'm going to see you that morning in this case. But obviously, that's a much more serious case you've got to deal with. The one I'm involved in is much less serious. Mr. Gary, do you have any questions?
What's your name, Trim? Yes. What's that case?
One of those charges is a violation of probation, and one of those charges is a written threat to kill against a judge, I believe, is what I just saw.
Well,
let me look. Judge, we went over this several times with him before. I mean,
I don't have no clue what y'all talking about. I don't even
I've talked to you about it a couple of times because you said you always ask, how could I have done that when I wasn't here? And I explained to you the first time in pretty much detail what you're accused of. So I'm going to see you in 2 weeks, Mr. Gary, and we're going to get you a lawyer appointed. I'm going to contact the presiding judge's office or ask the clerk to contact the presiding judge's office and tell him that case is stalled for some reason, but you're going to be in court 2 weeks, okay?
Okay, can I ask a question? What about my immediate family? I got family. I got a stepdad out there, and then I have a god sister that she's working, and plus she got kids, and I'm the only one my mom has left. My mom just passed while I was in here. So what did y'all expect me to do?
Mr. Gary, violation of probation charge is a charge you're not entitled to a bond in Florida. And the judge presiding over your case, which was not Judge Garcia, the judge presiding over your case has set a no bond warrant on your case. So you've got no bond at the time being because of the charge you have.
But Your Honor, I've been paying on my bond, my fine. I've been paying on it. I paid.
That's not what violated your probation. What violated your probation was getting new charges, sir. You keep getting charged with crimes while you're on probation. That's why you have no bond.
How can I do that? I mean, my probation was transferred to Alabama, right. And I ain't been.
Mr. Gary, you need to talk to an attorney in private. I'm doing my best to get you an attorney appointed. I'm gonna work on that after court. Okay. Have a good day, sir.
In our last hearing, I think it was a little over $1,000 still remaining at that time. Yes, correct? And that's been paid?
Yes, sir.
Okay. Jeannie LeBlanc from probation, you verify that has been paid, so the balance is zero.
Yes, sir. As of July 28th, the balance on restitution is zero.
Okay. Now, then what do we do today?
Previously, the court heard testimony or a plea from Mr. Sims. He admitted to the violations of the motion to revoke probation. At that time, there was several $1,000s worth of restitution that was still owed. Mr. Sims informed the court that he had about $1,000, a little over $1,000, and it had not been paid as of that time. The court told Mr. Sims that he would be sentenced to 2 years in the state jail, but gave him time to think about that. Over the weekend, the money that they had in their possession, I'm not saying it's him, it was his wife, paid that restitution to probation that afternoon, on the afternoon of the hearing. We came back to court and she had paid some more and basically got the restitution, which was originally
that's great.
But paid it all. Okay, and so the court reset it again and basically told them that you would not consider doing anything else until the restitution was paid.
Okay.
And that was about a week and a half ago.
Yeah. Okay.
I believe that's.
Well, it's time for us to do something.
Yes, sir.
How much credit does he have now? You would know. How long have you been in custody in this whole experience?
A little over 5 months.
And last time you had pleaded true to failing to provide verification of community service hours. And Ms. LeBlanc, can you refresh my memory? Was it just a few community service hours he failed to honor, or was it a lot?
Your Honor, he was originally ordered for 400 and he completed 40. So he has a balance of 360.
Oh gosh. Okay. Okay. I see. All right. Okay. What? Go ahead. Anybody?
Well, Your Honor, they would just leave with the court. The defendant, he did abscond from 2016 up into the present, and he never actually went in and saw the probation officer. He did pay the restitution, so I'll leave it to the court again, whatever you think is proper.
Only absconding is not a good thing. That's a bad example.
Yes, Your Honor. Maybe a year state jail, Your Honor. Whatever.
Judge, Mr. Sims would ask the court if you consider reinstating him on probation, realizing the things that he admitted to everything, all the grounds court asked him about, everything was true. So we're not denying that. But I think that paying the restitution shows his attitude. And I believe he would like to show the court that he can do probation. He didn't. There's no excuse for why he didn't. He has a job if he can be released. There are some other obligations. For example, he couldn't do the community service really while he's in jail very well, but he could do that now. I'm stricken with a position here, Judge. It might be better for him to get sometime in state jail just to get it all over with. But he wants to ask the court to reinstate him, realizing it's going to be, we're talking about years here. We're not talking about 6 months or something. Well, it could be.
How long had he absconded? What was
his last face-to-face contact with Hardin County, where courtesy supervision was 2016.
Yeah, years.
Yes, sir. Years. And Your Honor,
that's hard to purge,
yes,
because what's good for him and is fair for everybody, and that's what we try to strive for is a pronouncement of disposition that's fair for all concerned, not only the defendant but for people who have been in similar circumstances. And we send a message. My message would be, hey, abscond for several years. When and if you get caught, we'll just pick up where we left off. And that if the whole idea about supervision, probation is being there. And when you're gone, you can't be supervised. You're under your supervision, which is upside down for the plan. So.
And Your Honor, if I could just advise the court that Mr. Sims' case was actually a 5-year deferred, and it expired in
2019.
In 2019. So to continuation on probation, he would have to be adjudicated to be placed back under adjudicated probation.
But, Mr. Grove and his advocacy has given me some things to think about, but these circumstances similar to this, which don't happen a whole lot, but it happens. I've already thought about those. I've passed down that road before, and the problem is you got to just have the courage to show up, and then we can help fix everything. But when you're gone, the whole system of probation and supervision collapses. But anything else?
Yes, sir. As the court knows, in the last several years, we've had an abundance of restitution issues. Just about every case seems to have restitution issues in it. It's very important to the court, and I know it's very important to probation to get that paid. I've never seen a situation, though, that occurred like this. There's no justifiable reason why he didn't make the payments early on, but the effort that has been shown by Mr. Sims and by his wife mainly, it's just one of those things that I think that would be an encouragement to possibly have restitution become a lesser issue, because it seems like every case I have, Judge, is restitution. Yeah, it's just one of those things that we didn't used to have problems with.
Well, because people, are one of the 3 deadly sins. Live honestly, they're not living honestly. They're harming others by taking money, and they're not giving the person the respect that they deserve. The 3 sins, the 3 things of living admirably together on the planet. Those are the 3 basic elements that all commandments, laws, all dovetail into. And here, when somebody's stolen from, you just can't say, well, okay, we'll do some more time and go on. The person, unlike, and I'm just going to be quick on this, unlike breaking an arm or my God, killing someone, which you can't bring back alive, and you can't unbreak an arm. You can fix it, but still the person has problems generally their whole life, and when you take something of value from someone, you return the value. And that's how you can fix it so that it's unbroken. Unlike fixing an arm and going back in time and fixing an arm. When it's broken until it's fixed, but it's still broken and people go through pain and recovery. Here, you're lucky. Well, you're not lucky, but you're in the state system. In the federal system, interest is charged for loss and restitution. I was in the U.S. Attorney's Office for 20 years. And and to me, that made all the sense in the world, because if somebody's out their money since 2014 and you give them back dollar for dollar, well, they're at a loss. They didn't have the money to use, and money now is not worth the same value as it was 7 years ago, 8, 9 years ago. So the federal system puts an interest calculation on that, so that when people pay it back, it's paid with extra money that account for the difference in value. We don't do that in the state. So even when you pay it dollar for dollar, it's not, those people, the victims hadn't been able to use their money for 9 years. I'm glad it's paid back. And the state is accurate in saying what I believe is a fair rendition of what the punishment should be of a year in the state jail.
And Your Honor, I'm sorry to interrupt, but what the state's original recommendation was 24 months, so it has taken into account that.
Mr. Grove on the other side coin is also correct. Unfortunately, not often enough do we get people paid back on restitution. And it wasn't you. You should have done it. I know you're here in custody, but you still should have done it.
Yes, sir.
It's your responsibility, not your wife's or whoever, the family. You know, shame on you. You owe them too. They're the one out now because of your mess. All right, here's what I'm going to do. I'm going to, if nothing further, I'm going to find there is a, did you want to say anything? Okay, if nothing further, I'm going to find there is sufficient evidence supporting this motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 1 has been proven true, as the defendant has pleaded true to that voluntarily, knowingly, intelligently, that is, failing to provide verification, performing community service hours as required. And the court would also note that the defendant absconded for years, and that which was a significant part of the loss of that community service. So even though community service, people shrug that off as being maybe some of the least important, it is important, a condition of probation. But absconding from probation and being on the books on probation, but really not being here, it's like you went to Mars and that's where you live for a while. Well, there's nothing we can do. We can't connect with you and supervise you. And you decided on your own unilaterally to defy an order of this court. And you decided, I guess the way you can be looking at your history, sometimes you decide that bullheadedness or whatever it is, stubbornness, you're going to do it your way, right or wrong. And you need to realize that sometimes you have to listen to voices who are maybe thinking more clearly than you might be thinking at the time. So I do find that there is sufficient evidence by preponderance of the evidence or greater to grant this motion to revoke unadjudicated probation. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony of credit or debit card abuse. And you were hereby sentenced to confinement in the state jail for a term of 6 months. You will be given credit for the time you have served, which looks like it's 117 days. So you have a couple of more months of service, but it's not 2 years. like I'm sure the victim might think you deserve for keeping their money for so long. And it's certainly not 1 year like the state request would have been, which is fair for all concerned. But I am sensitive about getting victims taken care of. And if I can pressure folks to see that they can be rewarded from a lighter sentence, but still you have to be held accountable for this. I'm looking at your behavior. I don't want to say this, but it's like you're not acting mature as your age. All of these are responsibilities. Young kids don't understand responsibilities. Adults should. You have not a responsibility to yourself, to your family, where they are, and to others that you deal with who are in a position to be victimized. Respect others. That's the third principle of living a good life. Honest, harming no one, giving people their due respect. Okay. Anything else? Nothing. And that is all on this. Thank you, Jeannie.
Yes, sir.
Thank you. Williams.
We're next on the record in People versus Bobby Joe Kincaid Jr., file 23-4816 FH.
Caitlin Borgia on behalf of People.
Kyle Travis on behalf of Mr. Kincaid.
Thank you. Mr. Kincaid apparently is still connecting via audio. He's in my hearing room, so we'll give him just a moment. Is that Mr. Kincaid?
It is.
All right. He's still not connected via audio, but it looks like he's trying to do so. Mr. Kincaid, can you hear us now?
Hello? Hello?
Are you Bobby Kincaid Jr.?
Yes, sir.
Mr. Kincaid, please remove your hat. We're here today on a status conference, Mr. Kincaid. I'm sure you recall that I had some discussions with Mr. Ziegler, the elected prosecutor, and your attorney last month, because I was concerned about the timing of some issues, but apparently, they convinced me that there was no need for me to take any action on your bond, and that instead I should give you some time to have discussions with your attorney and your attorney to discuss with the prosecutor. Do you recall that background?
Yes, sir.
And have you stayed in good contact with your attorney since that time?
I have tried to, yes.
I'm going to hear from your attorney because I'm a little bit disconcerted by that answer. Mr. Travis, can you give me some background?
Your Honor, the reason we adjourned and the reason we're going to ask for another adjournment is Mr. Kincaid has a new file. I think when we appeared in front of you last, he had been charged, but I hadn't been appointed yet, but we assumed I was going to be. That happened. We one appearance in district court. We have a prelim coming up the middle of the month, and are basically in the process of discussing that. So in the interim, Mr. Kincaid and I have spoken a handful of times.
So there are times where it would make sense to the court to resolve cases if they can be resolved similarly in time together. And that's not really for a court benefit, it's for a defendant benefit. There are times that it doesn't make that sense. And so what I'm concerned about, and I want to just drill down a little bit on the comments you made, is you said that there's a new charge and that there's a prelim. If you're going to have a preliminary examination, generally speaking, I know what that means in Kalkaska County in terms of how the prosecutor views the cases. I want to make sure my impression is correct. But if you're going to have a preliminary examination on the new charges, would that suggest to the court that you're going to have a trial on the new charges? And if so, why would I delay the outcome of these proceedings if you're going to be challenging the merits of the underlying case?
Well, Your Honor, I'm in communications to try and get some letters and some witness statements. We may not have that prelim. We may. I don't know. At this point, we are at an impasse, if you will, which is a similar problem that we are in the other case. I don't know for sure what ultimately we're going to do, but given that there's two files and they're not directly tied together, but they are very much in a matter of days of occurrence, and the issues with the new case even stem into this case and things that were found in the car during this case. So they're, in one sense, very related. In another sense, Your Honor, they're completely distinct. Largely, they're related because they involve Mr. Kincaid, and they involve the same couple of days of time in Mr. Kincaid's life, and a lot of the same players and same people. So I hear what you're saying. If we're just having 2 trials, let's just keep going. And I don't disagree with you, Your Honor. And I can't tell you that's not what's going to happen, but I'd like to basically flesh things out a little more and see if there's a way to make an offer. There is not a complete lack of openness to offer, at least in the file in front of Your Honor right now for Mr. Kincaid. We never may come to a resolution and an agreement, but there has been some somewhat viable discussions. There's also some discovery that it's my understanding, and the prosecutor can correct me, but there's allegedly something found that is sent out for testing believed to be a bullet, and it would, at least in my discussions with Mr. Ziegler, that will determine his position somewhat substantially. If that is what he hopes it is, believes it is, and comes back as such, he will probably take a much harder line with Mr. Kincaid. If it isn't, we may be able to come to a resolution. And that's not back yet on this case, to the best of my knowledge.
Ms. Borchard, as to any of that background, how do people interpret the background and what I should do?
Your Honor, I understand the court's concern, but at this point, we would have no objection to one additional adjournment to try to resolve the case. As to Mr. Travis's credit, it's possible we end up with 2 trials, but there is a definite possibility that we could come to some type of resolution.
Is it accurate as well that at least some of the information that's relevant to this case has not come back from the state police testing units?
That's my understanding, yes.
Mr. Kincaid, did you hear your attorney's request for an adjournment in this particular case?
Yes, sir.
Mr. Kincaid, put your cigarette out.
I'm in a house. It's so smoky.
I'm sorry?
I'm in a house and there's people that smoke. It's so smoky.
Mr. Kincaid, I want to be clear with you that whether or not you are in person in the courtroom or via Zoom, this is an extension of the courtroom. You are not, in my estimation, appearing for court. You look like you just woke up. You had a hat on when the courtroom started. You have smoke billowing throughout the screen while we're in a courtroom. For so many reasons, I'm going to tell you that that's unacceptable. So when you appear again,
I'm gonna have to use somebody's Wi-Fi.
Mr. Kincaid, the other thing is, generally speaking, when I'm in the middle of telling you something, you probably shouldn't interrupt and speak over me. You should probably hear what I'm saying so that you can actually understand what I'm saying. If you appear in the courtroom, virtually or otherwise, in the same way again, with hair looking like you just woke up, with a hat on, or with cigarette smoke wafting in and out of the screen, it's going to pose a problem for you because that's not a way that's appropriate for you to appear. Do you understand?
Yes, I understand, and I'm sorry. I'm at somebody's house because I'm using their Wi-Fi, and I can't help what they do at their own house. So
what you can help, Mr. Kincaid, is how you appear. And how you appear is directly dependent on where you choose to appear from. I'm telling you as clearly as I can that if I see that type of activity again, I'm going to make you appear from a different location so that I can ensure there's some dignity in these court proceedings. Because I'm not getting that sense from watching you during this important court proceeding. But all of the background comes to this point, which is your attorney's asking for a delay in this case because he thinks there's some evidence that needs to be tested and some other discussions that he wants to have with the prosecutor. Are you in agreement with that adjournment?
Yes.
On that basis, I find good cause to adjourn then. I'm going to set this matter for a follow-up status conference. Mr. Kincaid, if you need to be in a different location so that you don't have smoke wafting, do so, because you're responsible for where you connect from. Otherwise, make arrangements with your attorney to come here in person, and that would be just fine. We'll see you next time, Mr. Kincaid.
Thank you.
Thank you.
Assistant Public Defender Doppy Lube on behalf of Mr. Jones Ford. Mr. Jones Ford, could you please state your name for the record, sir?
Jamarion Jones Ford. Teresa Player on behalf of probation. Your Honor, Mr. Jones Ford is scheduled before the court today on a violation of probation. Mr. Jones Ford is non-compliant with terms ordered by the court in that he failed to return a signed probation order. He failed to report to probation as directed. He failed to complete the alcohol highway safety education class, failed to provide proof of his victim's impact panel attendance, and failed to provide proof of his AA meeting attendance. At this time, probation is recommending that Mr. Jones Ford be remanded to serve 5 days in jail for violations to date, that he report to the Washtenaw County Jail by 6 p.m., that we extend his probation term for a period of 6 months, that he report to probation in person on August 15th at 10:30 a.m., then as directed, and become compliant with all previously ordered terms by this court within 30 days.
Response.
Your Honor, we would like to plead guilty to the violations and provide an explanation to the court in opposition to the proposed jail time.
All right, I'll accept the admission to the violations. Go ahead.
Thank you. Thank you, Your Honor. Mr. Jones Ford is very eager to become in compliance with his probation. Unfortunately, shortly after being sentenced, since he lost his job while also being the primary caretaker of two small children who were both 1-year-old at the time. His wife works full-time, causing Mr. Jones Ford to be his children's primary caretaker. He was previously working at Walmart and lost his job in June 2022. Between his finding a new job and caring for his children, he was overwhelmed and failed to complete these obligations. He certainly regrets this failure to complete the obligations, and he's very eager to complete them. So we'd ask the court to permit him an opportunity to complete these obligations, become back into compliance with probation, and perhaps if the court, in lieu of jail time, the court could assign community service.
Sir, anything you want to tell me?
Yeah, I mean, everything he says is pretty much true. It got too much dealing with a 1-year-old and a 2-year-old. She started to work full time, and in the midst of me committing what I did, resulted me in losing my job. So it's been a pretty much since the beginning of this, since my sentencing to beginning of this year, all the way up until now, I've been taking care of both of my kids on a daily from
the
8
problem
a.m.
is if you, and that's what kids require, that you got to take care of your kids, but
I know
you did not even contact or talk to probation about any of this.
Right.
That could have just been a phone call. And then I don't know that we're here if you had explained your circumstances.
Right. Right.
I mean, and now you place me in a position where you just haven't done anything.
You're right.
Oh, I know.
And Your Honor, I would just like to update the court. When I send out the violation or the VOPs out to defendants, it's also sent with a letter advising them to contact me to fix, to try to fix things. I can also tell you that Mr. Jones Ford did call the office and he spoke with Elin, who went over the terms that he needed to complete and to keep us updated on a status with that. And then there was nothing done.
And I told her the exact same thing that I'm telling you guys today.
And that communication, Your Honor, was on June 30th.
And then even up to today, August 9th, he still hasn't done anything. All right.
I have no way of transportation anywhere, let alone to pay for bus rides or anything. Like, I have nothing. Don't have my own car. I have nothing.
You know what? Of rights, I ought to do exactly what probation's asking. But I'm going to adjourn this out to August 23rd, 2023 at 9 a.m. or as your Zoom invite indicates. I don't care how you have to do it. I don't care what you better find a way to get something done between now and then. I'm going to give you that shot. But if you come back here giving me that same swan song, you can count on a whole lot more than 5 days.
Well, I have a job now, so anything that I have to pay for, it will be paid for. If I
You need to talk to probation and get it straight, young man.
Okay.
I'm just telling you what I'm going to do if you come back here in 2 weeks and haven't done anything.
I got you.
23rd, 9 a.m. Thank you.
Thank you.
It appears by and through Jill Gillette, County Attorney. Ms. Higuchi appears in person and pro se. It looks like, ma'am, you are charged in count 1 with driving under the influence of alcohol or drugs. In that charge, the state alleges that on or about the 12th day of July, 2023, in Greenwood County, Kansas, you did unlawfully operate or attempt to operate a vehicle while under the influence of drugs or a combination of, under the influence of any drug or combination of drug, to a degree that rendered you incapable of safely driving. As charged, this is a Class B non-person misdemeanor. It has a fine of between $750 and $1,000. It has a sentence up to 6 months in the county jail. In count 2, you're accused of unlawful possession of the controlled substance, marijuana and or THC. This is a Class B non-person misdemeanor. It does not have the minimum required fine as the DUI does, but it has still a fine as high as $1,000, and it has a possible sentence up to 6 months in jail. In count 3, you're accused of speeding. The state is alleging that you are operating a motor vehicle at 94 miles per hour at a 60 mile per hour zone, 94 miles per hour in a 60 mile per hour zone. The fine could be up to $500, but the scheduled fine is $255. And then you have court costs, which in this case could be up to $158. Do you have any questions about the charges or the possible penalties I've gone over?
No, Your Honor.
You do have the right to an attorney. You can hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for a court-appointed attorney, or you can waive your right to an attorney and represent yourself. Or does she maybe qualify for diversion, Ms. Gillette?
Diversion may be possible for her. This is her first DUI.
All right. Now, do you know what diversion is? Ms. Higuchi, do you know what diversion is?
No, Your Honor.
It would be an agreement, a written agreement between you and the county attorney. She would want you to do certain things like pay your fines and costs, probably get a drug and alcohol and evaluation and comply. But if you were successful at doing what the requirements were, they would dismiss these charges against you and they wouldn't go on your record. Do you want to look into the diversion? See if you want to do that?
Yeah.
Or you can talk to an attorney before you make that decision. How would you like to proceed? Do you want to talk to an attorney first?
I would like to have that diversion, Your Honor.
All right. The officers can show you the way to the county attorney's office to get the application form before you leave today. And I will set this over to your next court date, Missy.
Yes. September 19th at 3:30.
That's your next court date. You'll need to be back here by Zoom September 19th at 3:30. But I will tell you, if you want that diversion, you might want to apply for that today and then get this. If you get this all completed by the 19th, you might not even have to come back to court. If you get your diversion and you get the contract signed and back to Ms. Gillette.
Yes, Your Honor.
Okay. All right. And if you want to hire an attorney, you're free to do so. And if you decide you need to apply for court appointed, you can get the application when you come in the door at the courthouse. Just tell them you want the application.
Your Honor, what is best diversion again?
Diversion would cause all of these charges to be dismissed and go away as if they never, it would be as if you were never convicted. Now the charge would be there, but it would show that they were dismissed. They'd be dismissed. The case would go away.
I will go for the diversion. Yeah.
Okay. I've got it that you're going to apply for diversion and that you're going to hopefully have that all done by September 19th. But if you don't, you have to be back here by Zoom September 19th at 3:30.
September 19th, Your Honor?
Yes, 9/19, September 19th.
I'll take the diversion.
Okay, well, you have to apply for it. You have to be accepted, and then you have to sign a contract to get it.
Yes, Your Honor.
Okay, now you're not on bond as I can tell. So you need to go before you leave town today to go to the court. You need to go over to the sheriff's office.
And Judge, she does have a bond. It hasn't been filed yet.
All right.
In the case.
I will continue the bond then with the condition that you come back September 19th at 3:30. Unless you have your diversion contract signed.
Yes, Your Honor.
All right. Is there anything further I can help you with before I let you go?
That's all, Your Honor. My ticket over here. I have this is what should I do with it?
Okay. All right. Missy, what is this the same thing you were trying to tell me about this earlier? Miss Gillette, what does she have there? Do you know?
That's a copy. That's a ticket. I took a copy of it and I emailed it to Jessica.
Okay, so
that's what she came in on because it had today's date. And then I found the bond sheet, which had next week on it.
So does she have to come back next week for that ticket?
No, those are the same, Judge. They're incorporated into the DUI case. It's count 2 and 3 of the complaint I filed. The ticket was never filed.
Okay, well, what I'm seeing is 2 is possession of marijuana. Count 3 is speeding. And you have on your ticket speeding and possession of marijuana. Is that right?
Speeding and driving.
Okay. All right. So it sounds like just save that and give that to you. Well, just save that for your records.
Oh, thank you, Your Honor.
Okay. You're welcome.
All right. I will go here right now to file the diversion.
To file the diversion. Yeah, the officer will show you where the office is to go get the diversion form.
Thank you, Your Honor.
You're welcome. Thank you for your time, and you are free to go.
Thank you so much.
Again, you're welcome. Thank you. All right. So the lady on the screen at the jail is Mason Richard. No, that's not. What's her name, please?
Danielle Burton.
Thank you.
Yes,
we're on the record in 2023 CR 177. State of Kansas versus Danielle Lee Burton. Jill Gillette, County Attorney for the state. Miss Burton in person and pro se. Miss Burton, you're here for your formal first appearance on a number of charges. Count 1 is possession of the controlled substance methamphetamine or MDMA. This is a level 5 drug felony. If convicted, you could, depending on your criminal history, serve anywhere from 10 to 42 months in prison and pay a fine up to $100,000. In count 2, you're charged with the unlawful possession of drug paraphernalia, a class B non-person misdemeanor. If convicted of possessing a vape pen, rolling paper, spoon, and metal container for the purpose of storing, containing, concealing, injecting, ingesting, inhaling, or otherwise introducing a controlled substance into the human body, you would be facing a maximum 6 months in the county jail and a $1,000 fine. In count 2, you're accused with unlawful possession of marijuana or THC, its active ingredient. This is a class B non-person misdemeanor. You could serve another 6 months in jail and pay another $1,000 fine. Finally,
ma'am, I've been clean. I've been clean 14 months, ma'am. Clean this over 14 months and 2 days.
All right.
The stuff that was in that vehicle was not mine.
Well, let me finish your charges. In count 4, you're charged with transporting an open container of alcoholic beverage, specifically 2 bottles of Fireball, an unclassified misdemeanor.
It was not mine either.
You could pay up to a $200 fine. You could serve up to 6 months in jail or both. So, did you understand what you're accused of?
Yes, ma'am.
And did you understand the penalties I went over with you?
Yes, ma'am.
All right. Now, because you have a felony, you're probably going to need an attorney. Are you going to hire an attorney or apply for court appointed?
I'm going to have to apply for a court appointed one.
Are you working at this time? Do you have a job?
No, ma'am.
When was the last time you worked?
I worked home and health care, but it's been probably 6 months, ma'am.
You worked, it's been 5 or 6 months since you worked at home health?
Yes, ma'am.
Okay. All right. And are you married or single?
I'm single.
And do you have children that you legally support?
Yes.
How many?
3.
And how do you survive without income?
I don't support them. My daughter, my youngest lives with my son. My youngest son lives with my daughter, and my oldest son lives with a friend. But I do support them as much as I can. They don't physically live with me though at the moment. My youngest son, my middle son was living with me.
All right. I'm going to appoint an attorney, and I can't tell you who it is right now, but my assistant will look into it and give you an answer as to the name and contact information later this week. Make sure you find out who that is before you leave jail. If you can, if you don't, you call my assistant, Missy, and they can give you her number.
Yes, ma'am.
And your court date, Missy, when is her preliminary hearing control?
September 29th at 1:30.
You and your attorney will need to be back here by Zoom September 29th at 1:30.
Is my bond going to be lowered, ma'am?
Well, let's see. What's it set at now? 25,000 or what do you have there, Deputy?
12,500. Let me just double check here.
Okay, 12,500 is the scheduled bond based on the charges you're looking at.
Yes.
Where do you live?
I live in Kansas City, ma'am.
Missouri side or Kansas side?
Missouri.
Who do you live with?
My mother.
What does your mother do? Does she have a job or?
No, she doesn't.
How does she survive?
She gets a check every month.
Social Security or what?
Yes, ma'am.
Does she have anybody else living with her?
No.
When was the last time you stayed with her?
Maybe 2 weeks ago. Me and my brother Brian was trying to get a place. We was trying to move out of Kansas and into Wichita City to get to better our lives, and it just all went downhill. We was there for maybe 3 days.
So if you were looking, did you mean Wichita, Kansas?
Yes, ma'am.
So how did you end up in Greenwood County?
We was going back to get a load of our stuff.
I see. And you got stopped for traffic and?
Yes, ma'am.
Okay. Okay, so you're kind of between an out-of-state home with your mom, and did you get an apartment yet?
The only place I'd have to go is my mom's.
I'm sorry, I didn't hear you.
The only place I would have to go is my mom's, because the house, I'm sure we were supposed to have $500 by the next day for the rest of the deposit, and we didn't. So, or we would get evicted, and that was Saturday. So okay. I'm sure we lost the place. So the only place I would have to go is my mother's.
Okay, that must have been your brother I met earlier today.
Yes, ma'am.
Ms. Gillette, what have you to say on the issue of bonds?
Judge, she's from out of town. She has a 43-page criminal history. Her possession of marijuana is a second. Her possession of meth is actually going to be a second or subsequent conviction as well. I would prefer that she have a cash surety bond and a bondsman. She's had aggravated failures to appear. She has one of those out of Wyandotte County, among other failure to appears. And she's had lots of prior felony charges and issues. She actually has been down in this area before, because she had a flee and elude in Butler County that she was arrested for in 21. And then she, in that 21 case, had a conviction for fleeing and attempting to elude officers. And she had an aggravated failure to appear again out of Wyandotte County. And then we have these new arrests, but she has quite a bit of history, including running, both from court cases and from officers.
It sounds like that $12,500 scheduled bond is low for what it could be. With those added factors, it could be much higher. So, Ms. Burton, I think you best leave that alone, and I'm going to keep it at $12,500, cash or surety required. So, talk to your attorney when you get your.
Is that $12,000 with the bondsman?
Well, it's $12,500. A lot of bondsmen go 10%, but that depends on you and the bondsman's arrangement.
So would that be like
10% is $1,250.
So that's $1,200 to get out?
It's what your bond set out to get out. But call your attorney when he's appointed or she's appointed. And if that's probably pretty conservative with all those failures to appear and flee and elude.
I'm taking care of all that though, ma'am.
Yeah, but it shows you've got a tendency to run from your legal obligations. So,
no, I've handled all of that though. It's
all right. We'll talk to your attorney about that and then we can revisit that. But that's my order.
Okay, I appreciate you. You have a blessed day.
Thank you. You may go.
Did you come into contact with a nurse at the facility?
Yes, I did.
And if I told you who her name was Lisa Reynolds, I'm sorry. I'm sorry, I won't give that. But at that time, did you cop a feel of this person's buttocks?
Yes, I did.